All right. I think we have everybody, so we're on the record. State of Ohio versus Brandon Jonathan Hagel, case number 20-156. This hearing is being conducted by Zoom. Mr. Hagel is appearing from the jail. His attorney is out of Deardorff, she's appearing from her office. The prosecuting attorney, and Collins, is appearing from her office. The defendant was convicted by jury of kidnapping and robbery, and the court did recess that sentencing hearing because of a couple issues, one on murder and one of the post-release control, because the defendant was arguing that there was only less than 365 days left, and the state was arguing, I believe, the number was 687, based upon the notice to the court that was filed on January 12, 2022. All right, now before we go forward, Ms. Deardorff, you and your client are both agreeable to this hearing being conducted remotely by Zoom rather than his in-person appearance in the courtroom? And you're in agreement with that, Mr. Engel?
Yeah.
All right, well, since you and your attorney are not together, seated at the same counsel table, if at any time during this procedure or proceeding you would like to speak with her or she with you, just indicate that in the court, which was called a breakout room, where just the two of you be able to see each other and hear each other, and no one else will be able to see or hear you, okay? All right. So, I believe where we stood at last hearing was the court, or the state was taking a position that there was no murder, and the defense was. Does the state wish to address that issue?
Other than what's in our memorandum? I was confused that our memorandum said about rearranging the entire thing.
All right, I did not see that, so let me take a moment here to read that.
Oh, okay.
Okay.
It was filed on the 15th.
Yeah, I have it. All right, just addressing the merger issue first, and, Ms. Deardorff, is there anything you'd like to add to, your memorandum regarding the merger issue?
No, just from the case law that I cited, actually, here, a lot of the case law, the state of Ohio cited, particularly speaking Logan, and the case that I relied upon, the state Logan in Ohio Supreme Court, case that held kidnapping and aggravated robbery are allied offenses, and in state Logan, which the state cited, it said that it was a keeping of 30 years of precedent. I won't reiterate all of my arguments, but I do believe that the case law cited by both parties does indicate marriage.
Ms. Collins, do you have anything else you'd like to say on that? All right. Well, my reading of the case law, I made this comment previously, is that the last 15 years of jurisprudence on this issue has been put what I was originally a very clear-cut concept being applied by the courts, particularly when I was prosecuting them, until they started to look at these things, coming up with various discussions, and ended up overruling some cases. And the most recent case is the Rupp case that is from the Supreme Court in terms of supposedly clarifying and setting forth what the standard is the court is required to follow. And it's a three-pronged test, and that is that if they are dissimilar in import or significance, in other words, each offense cause separate identifiable harm, offenses were committed separately, or they were committed with separate animus and motivation. In that case, then they are not offenses of similar import and no merger occurs. In this case, and one of the things that the court said in my case is that the court is required to, essentially, the court is required to look at conduct, but not just in the abstract. And so, when we look at the evidence that's here, it appears to the court that the offenses were totally intertwined. It appears that the motivation for the restraint was for the purpose of committing a robbery. Although ultimately there was a lot taken, but there doesn't seem to be any other separate identifiable harm or any separate animus or motivation. And based upon the case law that existed prior to the Johnson, Morales, Rance, and Rupp cases, I think it's very clear. All right, hold on a minute. I'm going to mute this Sturgeon there, her mic is on. All right, and so the court, applying that three-pronged test, is of the opinion that these offenses are of similar import and are diverse. And so based upon that, the court will find murder applies. So with that, Ms. Collins, which offense does the state wish to elect to have a defense sentence on? Okay. All right. I'll go ahead and give each side an opportunity to make any further statements regarding, hold on, before we go to matter sentencing. Then, in terms of the PRC, I've read the memorandum, and it appears, Ms. Deardorff, that there are two periods of your client being an absconder, and that is clearly the law, that if somebody is at large or absconding, whatever term you wish to use, whatever the APA calls it, then that time is not counted. So, do you have any thing you'd like to say on that issue?
Not legally, Your Honor. We still are asking the court to take discretion and deciding to impose the PRC time.
Okay. All right. Well, then I'll do that. All right. Now, anything further from the state regarding sentencing?
And as to the amount of time spent in that.
Yes, yeah. I mean, anything you'd like to say, I'm just reopening it back up. So.
Your Honor, we would ask for a substantial pressure from this case. We would know that the defendant's relationship with the victim is actually what allowed this crime to take place. The testimony was that the defendant and Justin actually went to high school together, and they knew each other since they were kids, grew up together, things of that nature. So he is in the position that his relationship with the victim actually was a predicate offense for this crime. The defendant's criminal history speaks for itself. The fact that he is on PRC and he's a violator of PRC, he was not compliant with PRC while he was on it. During the pendency of this case, he remained on PRC and there were problems. There was a warrant after his arrest for quite some time that happens a lot in this case, and which is surprising since as somebody on PRC has been very easy to find. And finally, I would note that the harm caused in this case is substantial. I don't know if the court has had the opportunity or if the court has seen the exhibits, the pictures from the meeting that Dustin.
I saw that at the trial.
So the court is aware of the harm caused in this case. That this victim suffered a serious beating. So based on all that, we would ask the court to impose a significant prison sentence in this matter. Thank you.
I do have a question on Mr. Holmes' co-defendant. I believe his sentence was 5 years.
That's correct.
He was not on the PRC at the time.
He was not under PRC at the time, ma'am.
Okay. All right. Thank you. All right, Ms. Dearborn, on behalf of the defendant.
Thank you, Your Honor. So I'm asking the court to consider 3 years in the Department of Corrections for the sentence for Mr. Hagel. I did attach 2 character references on his behalf. I have since received additional character letters and just mailing of that memorandum. It really speaks to, and why I think they're relevant, and I know sometimes character letters don't directly relate to the sentencing factors, but it demonstrates Brandon's change since 2018. He has been a completely different person since then. He's become a father, he's become engaged, he works, he goes to church. One of the letters was from a business owner that is also a reverend. He said that Brandon has helped him with his house. He's come over to do free labor for him. He's gotten to know him every Sunday at church in addition to that. In terms of the outstanding warrant, I will note that he was arrested for this originally. I just wanted to comment on one thing. In Hillsborough Municipal Court was where this started, and those charges were dismissed in the preliminary hearing, and then a direct indictment came out almost 2 years later. So I just wanted to add that this was not something where he was in court and it was dismissed, and then later he filed, and then was ultimately served with the indictment. So I just thought that was important to clarify. But he has so many people that care about him. I know that the conviction speaks for itself. This is a very, very serious charge. But we're just asking the court to impose leniency on him. I've gotten to know him over the last few months. He's come into my office to talk about the situation. I think even in his testimony, he expressed remorse for what happened with Justin. And so if that wasn't clear in his testimony, I can say that that is something we discussed very, very often about the whole case. I know that when he was given an opportunity to speak, did not ask for a specific number. So I just wanted the court to consider that and be thoughtful about, this taking him away from his family. Because that's really what my goal comes down to. And I don't say that often in mitigation, but I just want him to be home with his family as soon as possible. And if anything comes from our mitigation, that's our primary goal.
All right. Mr. Engel, anything you'd like to say? All right. And is there anyone else that like to make a statement regarding this matter?
Yes, Your Honor, I would.
What is your name?
My name is Lorraine Lewis, and I am Eagle's fiance.
Okay, go ahead.
I had written you a letter, but I was unable to include it. so I was just going to read some of it to you. I have no brain injury in my life, and here I know the gravity of the crime was being convicted of. It's still hard for me to wrap my head around that. Frank is not the same man that he was 4 years ago. He was involved in the situation. He's always been there for me, my children, my family. And it's not just my niece's ability. He fixes things in my home, he fixes my car, he takes care of my children. As a father woman, my neighbors, my elderly people. He's helped me and my children have a better relationship with God. He personally baptized both my children. They're 8 and 9 years old. He has completely turned his life around for good, and I truly wish that you guys could just see that. Brayden also has a 1-year-old son, and I'm here to never even know his father now. And I know in my heart that Brayden is very remorseful for what he has done, and he has learned from his previous actions. He is a better man, and I'm proud to love him, I'm proud to have him raise my children. And since these charges were brought upon him, he applied to all your bail of these conditions. He reported to Hagel County Probation Weekly. He passed every drug and alcohol test given to him. And with these charges, he hadn't been in trouble for years. So I'm just respectfully asking you to please consider a lesser sentence for him so that he can improve our faith. Thank you.
All right, anything else?
Just for what it's worth, and I can say this to make on the record, Brandon is emotional right now, and I know he has been for the last few months of this case. I don't know if that's something that the Zoom can convey, but I think it's important to be consistent with my representation of that. Thank you, Judge.
All right. Well, one of the things that I did note when I heard the testimony and saw the exhibits, the incredible brutality of this, was that the sentence that I imposed on Mr. McComas was not commensurate with the harm. And had I been aware of, and that's one of the things, since he pled guilty, all that wasn't properly. And in hindsight, if I had known then what I know now, there would have been a 5-year sentence, it would have been substantially more. The defendant's conduct was not in terms of inflicting the physical harm, but in aiding and abetting. And it's clear that the quick verdict, the jury totally rejected Mr. Hagel's testimony and his version of what happened. And it's very clear that his connections to the victim is what enabled this to happen. And in terms of the actions that he took were clearly, as the jury found, one of aiding and abetting, not one of remorse or trying to stop it or anything else. He took no action. And in fact, the witness, the eyewitness's testimony, the woman that slowed down and saw and said he was yelling at the victim, yelling at the top of his lungs. 2 men were standing over. And then after that, they get back in the car and he drives again. And then, even more telling is his conduct once they finally did leave the vehicle and leave the victim, as he took no action to do anything, reported, make sure that the victim was found or helped. And so, it's pretty obvious why the jury found that he was a aider and abetter, was complicit in his offense. But in view of that, the court does not feel that it's appropriate to sentence the person who's a victim aiding and abetting to a greater sentence for the same conduct than the principal. Like I said, the principal, I had this evidence in front of me, it would have been a much more severe sentence of 5 years. But so therefore, it is the order of the court, the defendant being is hereby sentenced to a period of 5 years. And see, that's not mandatory time, Ms. Collins. I'll think under the statute. No. So it would be 5 years of the Correctional Detention Center at Florida, Ohio. And according to the sheriff's certificate, he has 46 days of jail time credit. May 18 of 2020 to June 2nd. 16 days, 8/31/21. For 9/14/21, 15 days. March 7th to March 21, 15 days. So that'll be applied to the credit. Now, upon completion of this offense, or sentence, let me back up. In looking at the post-release control issue, I've heard the claims that Mr. Hagel turned himself around, but yet he had two separate long periods of absconding from supervision by APA. On May the 14th, not 9th, the 18th, May 14th and 20, and August 25th to 28, 31, and 21. So that's not somebody who's become a law-abiding citizen. You don't turn yourself around when you're running or fighting the law or being accused, which is basically what he was, even though he apparently was living with Ms. Lewis and working. Nonetheless, he was not doing what he was supposed to do. So if somebody's truly changed the way they do things, then they will follow the law. He was hanging out with another convicted felon. He was involved in a new crime while he was on PRC, a brutal crime. And so the court does order that the defendant be sentenced to serve an additional period for committing the offense while under post-release control in the Claremont County case, and according to that, 687 days as of March the 8th, 2022. Today is March 21st, that's 13 days. So that leaves a balance of 674 days. And so it's ordered that the defendant serve that, and that be sentenced. And that sentence be able to be served consecutively to the sentence in this case. Now, upon completion of the prison term in this case, the defendant will be placed upon post-release control. It's mandatory, meaning you're going to be supervised by a parole officer in the terms that they set. You were before, at least you were supposed to be supervised. You were sometime, but not all the time, which is why you're in the situation you are now. And that will be for a period of at least 2 years, up to a maximum of 5 years. Now, if at every time the APA determines that you have failed to comply, they can return you to prison to serve an additional period as a sanction for up to 9 months for any one violation, but there is a half of the prison term for all violations, which in this case is 5 years, and the cap is 2.5 years. But, as in this case, if you've been a new felon, while you're under post-release control, and then in addition, whenever sentence a judge in a new case imposed on you, that judge is also authorized to sentence you for committing that crime, in this case, one additional period of 1 year, whatever time left on the period of post-release control, whichever is greater. That occurs, that has to be served consecutively with the sentence in the new case. Now, you're also ordered to pay the court bonds or judge the grant execution order. If you fail to do that, the clerk can collect that through various means, including levy, bank accounts, wages, earnings, and other assets you may have. That doesn't collect it then in addition to, or once you get out of prison, not while you're in prison. The court then can order you to do community service in this county and give you credit for each hour you work, and an hourly rate set by the court each hour you work, reduce your judgment by that amount until it's paid in full. Now, you have the right to file an appeal in this case, Mr. Hagel, to appeal your conviction and or sentence or any legal errors that you feel could have occurred in this proceeding. You must file an appeal within 30 days of your sentence and entry being filed, which will most likely be tomorrow. You are entitled to have the papers from your file and a transcript of any proceedings and any other papers that are necessary for you to prosecute that appeal. You also have a right to have an attorney to represent you to prosecute that appeal. If you cannot afford to hire counsel, or if you cannot afford to pay for the transcripts and papers that are necessary to prosecute your appeal, then upon a determination indigency, the court will appoint counsel for you and also order that the transcript of the proceeding, including the transcript of the trials and hearings, will be provided at no expense. But you'll need to consult your attorney about that and need to let the court know at the earliest possible date All right, is there anything further from council?
I'm not. No, sir.
All right, to remain in custody of the faith of the institution against 30%. Is this a one using hearing already?
We got Ison.
Okay. All right, Ison?
Mm-hmm.
Yeah, Mr. Ison. Okay, you're Ronald Ison?
Yes, Your Honor.
All right, there are two cases here involving Mr. Ison. Case number 19 CR 61, 19 CR 186. This hearing being conducted by Zoom. Mr. Ison is occurring from the jail. Attorney has been asserted in his office. Attorney on behalf of the state, Assistant Prosecutor King. Now, Mr. Kirk, you and your client both agree with this matter being heard by both hearing rather than in person.
Yes, Your Honor.
You all right with that, Mr. Ison?
Yes, Your Honor.
All right. In case number 19 CR 61, the defendant was convicted of several counts, as I recall. Yes, one count of illegal transportation of strap tires, and then 7 counts of illegal dumping of solid waste tires. Each of those were unclassified felonies, and the court imposed a sentence in this case. I can find this. Well,
Your Honor, the sentence in the 19 CR 61 case, so 4 years.
yeah, I'm looking to see where it is in the entry. Here it is, page 4. All right. Yeah, he had 2 years in count 1, 2 years on each of the other 7 counts to be served for a total of 4 years. And then in the 19 CR 186 case, he was convicted of a grand theft of a firearm and received a sentence of time loss. The court then granted him judicial release and put him in control. And he was released to the sheriff on September the 1st, 2020, and then conveyed to STAR program on September the 2nd, 2020. Now, on March the 8th, there was a notification filed that the defendant had allegedly violated the union control in that he had been found guilty in Montgomery County of aggravated possession of drugs, aggravated possession of cocaine. Well, he was found guilty of aggravated possession of drugs only, 53 pounds. And in Rule 7, that he had been administered drug screens on timely recovery on 3/1, 22, and 3/7, and tested positive on both days of fentanyl marijuana. The defendant was advised of that allegation on, I guess it was March the 6th, not the 8th, that's leading through a little bit. No, it is March the 8th. Okay, it's hard to see the same. March the 8th, that's the date that the officer signed. Court then notified Mr. Eisen, appointed Mr. Kirk to represent him, and sent the matter today for attention here. Now, Mr. Kirk, you have an opportunity to review these allegations with your client.
Thank you, Your Honor. I advise you to correct the hearing, because this is the right to set hearing and against the violations.
Okay? Mr. Eisen, you understand the allegations of what they claim you did that violated your community control.
Yes, Your Honor.
And you do understand you have a right to have a hearing in which the state has to prove you committed these violations. And you have your right to have your attorney cross-examine those witnesses and present any evidence in your defense. You understand that?
Yes, sir.
Now, you understand that in the event that you admit to these violations or you're found to violate them after an evidentiary hearing, I can do one of three things. I can continue your community control under the same conditions previously ordered, continue additional conditions I think are appropriate. The third, the most serious, is that I can revoke community control and judicial release and return you to prison to serve the balance of your 4 years and 9 months less any credits you have from STAR and any jail time on this charge that you served since you're released from prison on judicial release. You understand that?
Yes, sir.
Does anyone threaten you in any way to get you to admit to these violations?
No, sir.
Does anyone promise you anything to get you to admit to these violations?
No, sir.
All right, you have any questions then about your rights to these violations?
No, sir.
All right, then do you admit to the violations that I just read to you that were filed on March the 8th that led you to violate 1 and 7?
Yes, sir.
Right. Mr. King, on behalf of the state, anything you'd like to say?
Thank you, Your Honor. It's the state's position that this defendant is not immune from community control. Between the two cases before the court, the defendant was originally sentenced to a total term of incarceration of 4 years and 9 months. He was delivered to the institution in October of 2019. Approximately 11 months later, in August of 2020, he granted conditional release for the Pleas program. Instead of taking advantage of the tremendous opportunity and elected to commit and be convicted of a felony offense in order to criminal. The offense is given that the defendant has been convicted of a felony law, he can go back and be granted conditional release. The state has to be appropriate vote and then consent to the declaration.
Kirk, anything you'd like to say?
Yes, sir. In regards to my client, when he was released from the institution, he did go to STAR, did complete STAR. I believe he was there a reasonable amount of time. I think there were maybe rule violations, but I think they kind of extended his stay there. Upon release, obviously he did commit these violations, admitted that. They looked their non-violent offenses and the original case was non-violent as well. Every county has sentenced and they did commit community control for the offense. He was in a vehicle with his then girlfriend at the time, and there were drugs in the vehicle, so that's why he was charged. He's undone for that. He has been assessed by the treatment coordinator and treatment. They have been evaluating him for hospital capacity house. Because of that data available in this coming Thursday, treatment. In this case, this will be the first time that a oral treatment applied the essential STAR. He's showing how far he can do it, so I think it is a lot of drug treatment being applied in the case as well. That would address the substance abuse problems which surfaced since the last time. So he's really charged that he can do this over years. So this is kind of different for him. So we would ask the court to continue on community control, extend it if necessary, and review the indication of capacity notes and receive inpatient treatment. Thank you.
Guys, anything you'd like to say?
Me?
Yes.
Yes, I have a problem. See, also, I attended his very being honest, please grant me the chance to be nice now. I know what weird. I want to do it also. I know I'm a good person and I'm not. Please, thank you. I made a mistake. And I will. But it's all my history. It's all everything. Without drugs, I'm better. Just so that everything is done, we can do that. I promise I'll be again.
All right?
Just for the court's information, and I'm trying to step right here, like, there are very likely additional charges coming that would make this defendant eligible for, some programs.
Well, Mr. Ison, let me tell you, I was really seriously considering continuing this release until he's caught, because most of what came out of your mouth were lies. When you were sentenced originally and you had a PSI, your ORAS score was 5, which is just about as low as you can get. And in your statement to the probation officer that prepared the report, you reported that the only thing you'd ever done was marijuana. There was absolutely no claim of any drug problem. And when I review your PSI history, your criminal history, I see nothing related to drugs other than the possession of marijuana in 2018. Unauthorized use of property, theft, unauthorized use of motor vehicle, receiving stolen property. At no time in any of these sentences was there ever any issue for you to get drug treatment. There's no indication that there were no drug offenses other than possession of marijuana, which were misdemeanors, minor misdemeanors even. But what we have here is a continuous history of since 2001 doing many things, including jacklighting and illegally possessing deer carts, traffic offenses, but 1, 2, 3, 4, 5 previous theft convictions before you had this grand theft of an auto. And so, and it's interesting, you told the probation officer the very same thing you told me when you got your report. I'm a good person, and I work hard to get what I got. I always have done what I'm told to do by the court. Well, I told you what to do, and you didn't do it. And then you sit there and lie for your teeth. So it's the order of the court that your community control judicial release be revoked, that you be returned to prison, then you serve balance of your sentence. Walter, do you have his jail time, or I mean his number of days to start?
It's on September 2nd to December 11th. Sorry, hours.
All right. That's 90 days, and then he was arrested again on this charge. March the 8th until today, it'll be 13 days, so he gets an additional 103 days of jail time credit. Now, upon completion of this sentence, parole authority may put you under post-release control. Same thing I told you before, all that applies, and in the event that you commit a new felony under post-release control, you get more time for that, as I explained to you. So you're remanded back to custody. Then change your mind the next time, Mr. Rice. I don't know how long you got left, minus 103 days, you do the math. All right? involved with the same, wait a minute. I brought in, I brought in ISIS cases that to put that on Marsh's desk. Let's do. We have case number 22 CR 45, and then also case number 19 CR 202, both stable highway Karen Pepper. President of the State's Assistant Prosecutor King. President we have defendant as Attorney Dennis Kirk, and your Brandon Pepper. All right, Mr. Pepper entered a plea of guilty, last week to aggravated traffic methamphetamine in the city of schools out, a third-degree felony. And that was set for sentencing today. And Mr. Pettiford has also advised at that time that because the offense in that case took place while he was under community control in 19 CR 202, that constituted a violation of the rule that requires him to conduct himself in all quiet manner all the time, and then set for hearing on the probation violation as well at this time. Mr. Kirk, I want to thank you for your time today. Anything else you'd like to present before we ask for him to either admit or deny that?
I've explained it to him. His understanding would be obviously with the new charge that violates his own case.
Right, so Mr. Pettiford is here acknowledging that your conviction in 22 CR 45 constitutes a violation of your control conditions that were ordered back on February. I can't read that, but I have back off the date of stands. It looks like that would have been February 21st, 2020. It would have been rule number 1. You admit to that? All right. All right. Court now will proceed with sentencing. Anything from the state regarding sentencing?
Only was obtained to the agreement, Your Honor, under the restitution amount of $120 a month.
All right. Sure.
Thank you, Your Honor. In the new case, would ask court to follow the agreement. In this particular case, my client has engaged in treatment. It's currently enrolled in outpatient treatment. There's Ms. Lytle here today is the program director for First Capital. She transported him today. If the court needs any verification of treatment, and she reports to me that he has done well so far in treatment. And would know that just for the hope that when we reach the 6-month mark, that the court would entertain a judicial release. I know the court can't promise anything, because it all depends on how my client does at the institution. But would just note that. Would also note that my client was at the treatment the other day when the hearing was held, and very well could have not shown up today. He did the right thing, has shown up, and is here today to own up to what needs to be done and taken care of. So would ask the court to grant community control. And then in the 19 case, if the sentence could be fashioned in a manner that would allow for my client to be eligible for judicial release, so that if the court grants it at the 6-month mark or thereafter, that he would be eligible, so he could enroll in treatment again and pick back up where left off. And I've explained to my client that there's no guarantees here with any judicial release, but we're just having the hope that if things go well, he could apply and may be able to get back into treatment. Thank you.
All right, Mr. Pettiford, anything you want to say?
Yes, Your Honor, I'm here today because the worst thing before I understand that they full responsibility and accountability since being in rehab, I have totally changed, old personnel ordinance to myself, and everything will be this day and on, done the purpose of my life. I've been able to get bridges that I thought were burned, unburned. I'm not messing with it, it's really trying right now, but it's asking me to.
Well, case number 22 CR 045, the new charge, recommendation, one recommendation, 10% for a term of 30 months. It's for the court that should be in our hereby sentenced to the correctional center for a period of 30 months. And in case number 19 CR 202, you're found to have violated your control, and that is revoked, and you are sentenced to a term of 9 months in that case. Those sentences are ordered to be served consecutively to each other for a total of 39 months. In case number 22 CR 45, you have 2 days to get time credit, February 15th to 16th. And in the 19 CR 202 case, you had 63 days of time credit. Somehow you have a casual case in the time to apply to that. You have a total of 63 days. Now, the court finds that the second sentence is appropriate because the offense in the second case occurred while the defendant was not in control in the 19 CR 202 case. The court committed a second course of conduct, and one single sentence would not accurately reflect the seriousness of the offense. That different offenses, and the sentences are not disproportionate to the harm caused. And like a current sentence. Court also had that criminal history such that second sentence is necessary to protect the public. Court orders that in case number 22 CR 45 and the order to pay restitution $120 in Iron County task force that we would pay through the Iron County victim witness escrow restitution account, and then it shall pay any fees associated with that. Case number 19 CR 202, the order to pay the court cost. In that case, now, upon completion of the sentences, Mr. Pepper, to serve the entire sentence, it is possible that the adult authority place you on post-release control for a period of up to 2 years, and have to if they can. If they do, you'll be supervised by a parole officer under the terms set by the APA. And if during that period of time they decide that you have failed to comply, they can return you to prison, make you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term, which 39 months have to be 18.5 months for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case imposed, the judge would also sentence you to committing that offense under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to occur consecutively to sentences in the case. All right, so anything you put in the council? There. All right, your managing custody.
Yeah, Bridge, Your Honor.
Yeah.
Well,
Did you put in there about sentencing mergers?
Yes, it's right in there.
Are we not sentencing the offensive?
Yes.
All right, Douglas Peterson. Right of appeal, 32.1. Off the top of my head. Case number 22-65, Ohio versus Douglas E. Peterson. Present on behalf of the state prosecutor. We have Lieutenant Attorney Hackner. And are you Douglas E. Peterson?
Yes.
All right, Peterson is charged, along with two co-defendants in an 8-count indictment. He's charged on 8 counts, counts of aggravated trafficking and 4 counts of aggravated possession of different compounds for different drugs. This is the first pretrial, which was continued, and final pretrial set for April 13, jury trial set for April 9. So the state did provide the bill of particulars for discovery, and you got your discovery next on that.
I've got a record check here.
Right. We did like the final pretrial. Do you anticipate any pretrial motions?
Not at that time, but we'll reserve that to the second pretrial.
Okay. And has it been a written plea offer provided?
I have received a written plea offer. I have not yet had an opportunity to communicate that to Mr. Peterson.
Okay. All right. Are there any other matters then that need to be discussed?